Hi everyone, I'm David Fisher, and this is Presidential Chronicles, the series of books and videos on American history as seen through the lives of the presidents of the United States. This episode is from the life of William Taft. The focus is dreams do come true. The year is 1920. It's an election year. The Democrats, Woodrow Wilson, have been in office for the last 2 terms, but the country ready to kind of move in a different direction as the Republicans had reunified as a single party, and Warren Harding was put forward, the senator from Ohio, as the candidate for the Republicans. He ran on a campaign of a return to normalcy, and that's exactly what the electorate was looking for. It was a landslide win, Republicans going back to the White House. Now, Harding and Taft went way back. In fact, Harding had actually put Taft's name into nomination at the 1908 Republican National Convention. And so, as a courtesy, the former president went to Marion, Ohio to have breakfast with the president-elect, talk about some potential appointments in the administration. At the end of this breakfast, Harding says to Taft, by the way, I want to ask you, would you accept a position on the Supreme Bench? Because if you would, I'll put you on the court. Well, music to the ears of William Taft. He had already turned down the court 3 times. This was his dream job. He had turned it down 3 times during the Roosevelt administration for a variety of reasons. He probably thought that this ship had sailed and his chances to go into the court had come and gone. But this is still what he wanted to do. He told Harding as such, but he did put a caveat in. He said as a former president, he thought really the only position on the court that would be appropriate would be the Chief Justice. Well, Harding agreed. Well, what do you know that 74 days after Harding took his oath of office, the Chief Justice of the United States, Edward White, died, creating exactly the opening that Taft needed. About a month later, while Taft was out of the country on business, he was in Canada, Harding sent his name forward to the United States Senate. They debated it for a couple of hours, and he passed his nomination 61-4. The 27th President of the United States was about to become the 10th Chief Justice, the only man in American history to hold both jobs. Taft moved back to Washington, D.C., and in October, he was ready to go. In fact, he would spend just about every waking moment focusing on his duties in the Supreme Court. He wasn't interested in outside activities during this time, and there were 2 major facets of his job as Chief Justice. The court cases, of course, and we'll talk about a couple of those, but also the reform of the federal judiciary. This was a big deal to Taft, and he had a big impact. The big concern really was the backlog of cases, which were everywhere at the Supreme Court level, but across the federal system, at the circuit courts and the district courts. And this was a big problem. Taft believed in this concept that justice delayed is justice denied, and it was simply taking too long to get cases through to be justice for the United States and the American citizens. So yes, they needed more judges. Taft actually fought for that and would get some, but he really wanted structural reform. And for this, he was willing to work across the government. Separation of powers, don't worry about it. He'll work with the executive branch, with the legislative branch to get new legislation in place. He started to work with the Attorney General, Harry Daugherty, on a proposal that would create a council of judges. Now, in this instance, the Chief Justice would be the chair. The other members would be the senior judges from the 9 circuit courts, and they would get together at an annual conference, not to talk about cases, not to talk about constitutional issues, talk about administrative issues, balancing the workload across the country, standard administrative procedures, even the quality of libraries in the judges' chambers. This is what he wanted to focus on at these annual conferences, and this is the bill that was being pushed. Now, Congress was a little weary, never done anything like this before, and they were a little weary of Taft, trying to perhaps create an executive presence. A Chief Justice is almost the president of the judiciary, which has never been the case prior to that, but those concerns were actually pretty small. The reformers were in favor of what Taft was pushing. He successfully spoke at 2 different hearings, testified at 2 different hearings in the Senate Judiciary Committee. Those both went well, and the Judges Act of 1922 passed. In December of that year, he hosted the first of many conferences. The bigger change was actually coming ahead, and he fought for this again for the next couple of years. He believed that the Supreme Court, frankly, was wasting its time on a lot of these cases. They had to take every case that came to them, and he thought that was an inefficient use of their time. He believed in the concept of certiorari, which meant that the justices on the Supreme Court would decide for themselves which cases the court would take. Now, this was a complete change that the judiciary had never done before, but this was the heart of how Taft believed the Supreme Court could be most valuable. Let the circuit courts and the district courts handle the majority of cases, but the ones that really mattered, that really tested constitutionality, those should come to the Supreme Court, and they should be able to focus on them in a smaller quantity. Once again, there was some pushback in Congress about this, but Taft fought hard, and in 1925, this passed as well. In fact, the vote in the Senate was 76-1. These were major structural changes that William Taft was putting forward as the Chief Justice of the Supreme Court. Well, he certainly did a lot of work in the courtroom as well. In fact, he wrote more opinions, about 50% more opinions than any of his colleagues throughout his 9 years on the court. 266 opinions in all. Only 20 of those were in dissent, and there's a couple of reasons. Number one, he was in the majority most of the time. He had a conservative court that was either 7-2 or 6-3, leaning on the conservative side, so he was in the majority the most of the time. But even when he was in the minority, he didn't really like to write dissents. He was the Chief Justice. He believed in unifying the members of the court, so only 20 times did he take out his pen when he felt strongly to write a dissenting opinion. All the rest of those were in the majority. Well, to talk about a couple of these cases, and in the Taft court, you really did see sort of the second coming in many ways of John Marshall, who had been one of the early Chief Justices, served for over 30 years, and he had advocated, or he actually adjudicated, a very strong authority for the federal government. And Taft believed in this. In fact, he said of Marshall, I would rather have been Marshall than any other American. He made this country, and Taft operated along those lines as the Chief Justice. I'll give you an example. Just 1 year onto the job, 1922, Stafford v. Wallace. This case was an interstate commerce case that had to do with the Packers and Stockyards Regulation Act that Congress had passed. And some of the people in the stockyards in Illinois, in Chicago, cried foul. They said, this is none of your business, Congress. This is not interstate commerce. This is intrastate commerce. They only did business with customers inside the state of Illinois. Case went to the Supreme Court, and the Taft court disagreed with those folks in the stockyards because as Taft looked at it, they were part of an end-to-end supply chain. And if any part of that chain is part of interstate commerce, then Congress had the ability to regulate it. Again, this was a Marshall-like view of giving broad authority to the federal government that basically gave Congress going forward the right to legislate and regulate over just about any part of the economy that they wanted, because almost everything touched somewhere along the lines to interstate commerce. A lot of this came from the Taft court. Now, another case was actually very personal to Taft because it had to do with the powers and the authority of the presidency. This was the case of Myers v. U.S., 1926, in the case of a postmaster by the name of Frank Myers. Now, Myers had served 3 years out of his 4-year term, and he was terminated by the executive branch. Well, he sued because there was a law on the books that said those firings had to be approved by the United States Senate. Well, the government argued that that legislation should be considered unconstitutional, and the Taft court eventually agreed. But they looked at this much broader because this was a very similar case to what happened to Andrew Johnson, the 17th president of the United States, when he was impeached over the Tenure of Office Act. At his level, Congress had passed legislation that said he could not terminate an executive branch employee who had been confirmed by the Senate without the Senate's consent. Now, Johnson believed that was unconstitutional, but he couldn't get the fight into the court, so when he fired his Secretary of War, Edwin Stanton, Congress jumped at it, impeached him, and came within one vote of kicking him out of office. Well, this had been dormant now for a long time, and Taft was going to put all of this together into a single package, declare the postmaster legislation unconstitutional and the Tenure of Office Act unconstitutional, focusing on the take care clause in the Constitution, that the president must see to the laws being faithfully executed. And Taft's court believed they can't do that if their subordinates could ignore the orders of the president without any ramifications. And so 60 years later, the Tenure of Office Act was determined to be unconstitutional, and Taft said that I never wrote an opinion that I felt to be so important in its effect, both maybe righting a past wrong, but also a gift to presidents going forward. This is something they would never have to worry about again. Prohibition was in vogue at the time. That constitutional amendment had been passed. Liquor was illegal across the country, and a whole bunch of legal cases came to the Supreme Court on this topic. One of them was Olmstead v. United States, 1928. This was a bootlegging case against Ray Olmstead of Seattle. All of the evidence in this case, which was pretty strong against Olmstead, had been obtained by a wiretap. Now, at the time, there were no search warrants to get wiretaps. The police just did it. They tapped his phone. They got the information, they went to court, and he was convicted. Well, Olmstead said that is an illegal search. This is unconstitutional. Now, today, you would need a warrant to do that. But back then, according to common law, that the admissibility of evidence is not affected by the illegality of the means by which it was obtained. Kind of strange for us to hear that today, but that was the norm at the time of the Taft court. So Taft's court looked at this and said, this is not an illegal search. First of all, there was no search. There was no seizure. That wiretap didn't cross the lines of either of those terms in the Constitution, so this was legal, and it passed 6-3 in that decision. But it's really the dissent on this case that has a lot of legs going forward, and it came from the liberal side of Justice Brandeis. Louis Brandeis wrote, "They conferred as against the government the right to be let alone, the most comprehensive of rights and the right most valued by civilized men. To protect that right, every unjustifiable intrusion by the government upon the privacy of the individual, whatever the means employed, must be deemed a violation of the Fourth Amendment. The greatest dangers to liberty lurk in insidious encroachments by men of zeal, well-meaning but without understanding." It would take about 40 years before Brandeis's view would hold what we now know today about the need to get court sanction before doing many of these kinds of searches. So his would get the final word, but at the time, the Taft court stuck with the way things were for the norm, and that search was considered legal. The 1920s starting to wind down, and so too was William Taft. He did have the honor to swear in Herbert Hoover as the President of the United States, March 4th of 1929. That's the second time he had a chance to do that. He had also done it for Calvin Coolidge 4 years before, but Taft had health issues. He had suffered 2 heart attacks back in 1924, and in 1929, his brother Charlie died. He was very close with his brother throughout their entire lives, and against doctors' advice, he said, "I'm going to that funeral in Cincinnati." He made the trip, he came back, he was really weak, hospitalized, still not getting better. The Tafts went to Asheville, North Carolina, some rest and relaxation, hopefully get better. It wasn't happening. And so the sad duty went to Robert Taft, William Taft's son, to go to the Supreme Court February 3rd of 1930 and submit his resignation. Taft wasn't going to sit by quietly, though, while they figure out who the new Chief Justice was going to be. Charles Evans Hughes was his choice, and he lobbied the President, Herbert Hoover, to make that choice. Hoover did. It only took him a couple of weeks, which was a good thing, because 2 more weeks after that, William Taft died, March 8th of 1930. He still had one final gift that was being given to his beloved Supreme Court. He had been working for years to get the court its own building. This was an independent branch of government. It deserves its independent building, and for time since the beginning of the Republic, the Supreme Court had operated within the confines of the Capitol building. Well, Taft finally got legislation to approve the concept, the money. The executive branch actually put Taft in charge of making a lot of the decisions about this building, but he did not live to see it. It was 1932 when Chief Justice Hughes brought that building to life, and he gave credit to Taft at this ceremony when he said, "For this enterprise now progressing to completion, we are indebted to the late Chief Justice William Howard Taft more than anyone else. This building is the result of his intelligent persistence, yet another gift from Taft to his beloved judiciary." You know, Helen Taft, his daughter, said once that his years as president were the only unhappy years of his entire life. And that's pretty much true for the life of Will Taft. He had a rich life that was full of accomplishments. Number 2 in his class at Yale, Solicitor General, federal judge at the age of 34. He went off at the request of his president to step down from the bench to go and become Governor General of the Philippines, did a phenomenal job there, eventually came back to become Secretary of War for his close friend Theodore Roosevelt, who sent him all over the world from one crisis to the next, from Panama to Cuba, back to the Philippines. He did all these great things, and the one thing that he didn't really want to do, he eventually agreed to. Everyone was pushing him, go ahead, become president. He did. He did not like it. He did not do well in it. But fortunately, that tragic interlude was righted a bit in the end. When he sort of escaped the presidency, he went back to Yale and he ended up in his dream job doing major reforms as Chief Justice of the United States. So there were tragic chapters in his life, but mostly it was a heroic story for William Taft and his contributions to the United States. That is William Taft and Dreams Do Come True from the life of William Taft. For more Presidential Chronicles, check out my books on Amazon.com, and don't forget to subscribe to my YouTube channel. Until next time, I'm David Fisher, and this is Presidential Chronicles.